Chairman's final written address, I urge my Lord to grant all the relief claimed.
Thank you.
Yes.
Court case is adjourned to the 11th of September, 2024 for judgment.
Please.
We are most grateful, my Lord.
Thank you, sir.
Thank you.
Yes.
Yes, number 2. NICS/80/26, 2021 between Mohammed Dalhatu and Ahmad Bello University. Hello. Hello, the claimant is present. Defendant absent, hello.
Claimant present.
Yes, madam.
Defendant absent. Appearances, please. Do we have the counsel online? Yes. Who is in court? Is that Mr. Aisha?
My name is Ishaq. My formal appearance is for the defendant.
We don't have representation for the claimant.
They are not online, my lord.
Okay. Judgment. As a starting point, I shall state that this judgment was initially slated for the 3rd of June 2024, but the Nigerian Labour Congress embarked on a national strike on that day, and the judgment was further adjourned till today. The claimant's complaint and statement of facts for unlawful termination of his appointment were filed in this court on the 30th of June 2021. As claims against the defendant are set out as follows. We have 8 of his claims as stated on the face of the judgment. I'll skip it. It is right there in the judgment, please, just to save the time of the court. At the plenary trial, the claimants testified. Can they work on the microphone, whether it will work over there? At the plenary trial, the claimants testified in person by adopting a statement on oath as his evidence in chief and tendered 13 sets of documents in evidence as exhibits. He was thereafter cross-examined by the defendant's learned counsel. The defendant in turn fielded 2 witnesses. The second defendant, Professor Hafsat R. Hamad, testified as DW1, whilst one Ramatu Mohammed, the deputy registrar of the first defendant, testified as DW2. They both adopted their written statement on oath, and 4 documents were tendered in evidence. The defendant's witnesses were also subjected to cross-examination by the claimant's learned counsel. As gleaned from the statement of facts, the claimant was employed by the first defendant in January 2008 as office assistant, and upon confirmation of his appointment, he was posted to the pediatric section. The claimant's letter of appointment, letter of assumption of duty, and letter of confirmation of appointment were tendered in evidence respectively as Exhibit C1, Exhibit C1A, and Exhibit C1B. A summary of the claimant's case is that his ordeal with the second defendant, who also is the head of Department of Pediatrics, started on the 1st of April 2014. When about the close of work, he drew the attention of the HOD to a sum of money wrapped in a nylon bag, and the said HOD instructed him to keep the money as the money belongs to her. According to the claimant, when he approached the defendant the following day to give the money to her, she instructed him to drop it on her table while she was busy on her computer device. That he was surprised when the second defendant demanded for the money later on the same day and told her that he had returned the money. The matter was reported to the Secretary of Department when the money was not found. The claimant testified further that the second defendant made a report, that is Exhibit C2, to the University Security Coordinator that the sum of 411,750 naira was stolen from her office, that the matter was referred to the Junior Staff Disciplinary Committee, that is the JSDC, that he was invited to appear before the JSDC on the allegation of theft of the said sum of 411,750 naira, that he made oral representation of his innocence before the committee, that the committee in its decision in Exhibit C4 found him liable and directed the bursar of the first defendant to make monthly deductions of 11,437 naira 50 kobo, and the deduction was made for 37 months from September 2015 to 2018 to recover the sum of 411,750 naira. The claimant further testified that sometime in January 2015, a query, Exhibit C3, was given to him on allegation of theft of laptop and mini speaker. That another allegation was leveled against him in March 2016 for the theft of the laptop of one Dr. Abiola Olarokuba, that the laptop was later recovered from one Mrs. Hala Magani. The grounds of the claimant is that sometimes in March 2017, the Assistant Dean Preclinical wrote a complaint, that is Exhibit C6, against him on the allegations that includes illegal sale of foul jackets and removal of foul jackets from cabinets. That Exhibit CCA, that is, a query was issued to both himself and one Talatu Tanko for misconduct, that he responded to the queries. Exhibit C3A and Exhibit C6B, and when written and made written and oral representation before the committee, that the disciplinary committee that considered the allegations was not properly constituted, and the committee never tried him for illegal sale of student file, but he was tried for illegal sale of foul jackets. That upon appeal to the Vice Chancellor, he was invited by the JSDC on the 29th and the 30th April 2019 on allegations of theft of money, laptop, pair of mini speaker, technophone, illegal sale of student file, and unruly behavior, and that on 12th November 2019, his appointment was terminated by Exhibit C7 for illegal sale of students' file and unruly behavior. The claimant's letter of promotion and pay slips for the months of September 2015 to September 2018 were also tendered as Exhibit C5 and Exhibit C8, respectively. The defendants joined issues with the claimant by filing a statement of defense on the 8th of September 2021. Essentially, the defendant's defense is that due process was observed before the termination of the claimant's appointment. In her testimony, DW1 narrated the incidents of the 1st of April 2020. What is this now? I'll check. And the involvement of the claimant on the missing sum of 411,750 naira, and that was meant for the refreshment and logistics for the Nigerian Medical Council examination for foreign trained doctors. DW1 testified that a report was made to the security office of the first defendant, and that thereafter the claimant was invited to appear before the junior staff disciplinary committee. DW1 testified further that the claimant admitted that the money was not handed over to her but was only dropped on her table, that the JSDC made its findings and recommended that the claimant should refund the money and that the money should be paid to the second defendant's account in monthly installments of 11,000 naira for a period of 3 years from August 2015. The testimony of DW2 is that, amongst other acts of misconduct, the claimant was queried in January 2015 for removing laptop from the office of Head of Pediatrics Department, a pair of mini speakers from office of Dr. I.W. Human, that in March 2017, the Assistant Dean Preclinical of Faculty of Medicine of the first defendant made a complaint against the claimant for unruly and unacceptable behavior, and that in spite of several warnings, it was alleged that the claimant is engaged in illegal sale of file jackets, inflation of sale of file jackets, thereby exploitation of newly admitted students and removal of file jackets from cabinets. DW2 testified that the claimant admitted in his reply his involvement in the illegal sale of student file jackets and apologized for his mistakes. That in September 2017, the claimant was queried again for stealing a Techno W4 phone of his colleagues in the office, but that he denied the allegation in his reply, where the claimant was invited to appear before the staff disciplinary committee of the first defendant, and that based on the committee's findings, the claimant was recommended for deployment pending the final decision of the management. The testimony of DW2 is further that based on the claimant's appeal to the Vice Chancellor, the matter was referred to JSDC for investigation, that after the claimant made his representation at the JSDC, the committee made recommendation of warning on the allegations of theft of laptop, mini speaker, and technophone, whilst the recommendation was made for the termination of the claimant's appointment for the illegal sale of student files, and that his appointment was thereby terminated on that ground. The defendants maintained that the claimant was given opportunity to be heard during the administrative disciplinary proceedings and that due process was observed in the termination of his appointment. The extracts of reports of the JSDC of the first defendant was tendered and admitted in evidence as exhibits D1 and D1A. The claimant did not file reply to the joint statement of defense. At the close of plenary trial, parties filed and exchanged their written final addresses as prescribed by the provisions of Order 45 of the Rules of this Court. In the final address filed on the 24th of October 2023, Learned Counsel for the defendant, A. Isaac Esquire, raised 3 issues as having a reason for determination in the suit, namely, 1, whether the claimant has been afforded fair hearing in determination of his employment with the first defendant. 2, whether the claimant is entitled to the reliefs claimed 3, whether the claimant has a defense to the defendant's counterclaim. In the final address filed on behalf of the claimant on the 1st of June 2022, also deemed filed on the 7th of November 2023, learned claimant counsel A.H. Bello Esquire distilled 3 issues as arising for determination in the suit as follows. 1, whether in the circumstances of this case, the claimant has been afforded fair hearing in the procedure that gave birth to the termination of his appointment. 2, whether the defendants were right in the circumstances of this case when they found the claimant liable for the sum of 411,750 naira consignment, upon which the claimant was forced to refund the said sum. And 3, whether the defendants in this case have established a valid defense to the claimant's case. The defendants filed a reply of points of law on the 15th of November 2023. In the light of the reliefs claimed by the claimants, the evidence adduced by both parties on record, and the field of disputes between the parties, it is my view that the focal issue that has arisen for determination in the suit without prejudice to the issues already formulated by learned counsel on either side can be succinctly framed as follows. I quote, whether or not the claimant has established by credible evidence his entitlements to the declaratory and other reliefs being claimed against the defendants in the suit, end of quote. In proceeding to determine this issue, I state that I had carefully considered and taken due benefit of the written and oral final arguments canvassed by respective learned counsel to support their respective claims and the defense, as the case may be. I shall, to that extent, endeavor to make specific reference to their submissions as I consider needful in the course of this judgment. Now, the general principles guiding the proof of a claim for wrongful or unlawful termination or dismissal of employment have remained sacrosanct. It is a universal evidential principle that the burden of proof in any case is on the person who desires a court to give judgment as to any legal right or liability dependent on the existence of facts which that person asserts or who will fail if no evidence were given on either side. In labor law, it is equally settled that the onus is squarely on a claimant in an action for unlawful dismissal or termination of appointment to prove the existence of the contract of employment, the terms and or conditions thereof, and how those terms and or conditions were breached by the employer. Flowing from the above principles, the claimant hearing must not only plead and prove the terms and conditions of his appointment, he must also prove that there was a departure from the prescribed procedure, or that in applying the procedure, there was a violation of the rule of natural justice so as to render the formal compliance a travesty. See the cases of Nwachukwu versus Nwuse, Waek, and others versus Ikeng, Nigeria Gas Company Limited versus Dudushola, Oloruntoba Oju versus Abdurrahim, Imaswain versus University of Benin, citation all supplied. From the totality of the evidence adduced by the claimant, as he satisfactorily established his case for unlawful termination of his employment of his appointment to entitle him to the reliefs being sought, learned claimant's counsel argued vehemently that the allegation leveled against the claimants in the query was for illegal sale of foul jackets and not for illegal sale of student fouls and unruly behavior for which he was tried. Learned counsel made heavy weather on the distinction between foul jackets and students' foul jackets and whether there is any regulation in the first defendant's policy prohibiting the sale of foul jackets. Learned counsel argued further that the allegation of unruly behavior was never admitted and same was not proved, and thereby the termination of the claimant's appointment was unlawful. The grounds of the claimant is further that he was not given fair trial when his appointment was terminated for illegal sale of student file and unruly behavior, whilst he was tried on illegal sale of file jackets and unruly behavior. At this juncture, I should note that the motion on notice filed by the claimant on the 17th of May 2023 for an order granting leave to amend the statement of facts by adding and or inserting paragraph 32B was abandoned and not taken. Hence, the prayer was accordingly not granted. In that regard, evidence given in relation to the facts stated in the said paragraph 32B on the distinction between the sale of students' file and file jackets that was prohibited by the first defendant goes to no issue, and I so hold. As correctly submitted, where the evidence adduced at trial clearly revealed that the principles of fair hearing was observed, it is for the party alleging non-observance to prove the contrary. Fair hearing is not a cut and dry principle which parties can, in the abstract, always apply to their comfort and convenience. It is a principle which is based and must be based on the facts of the case before the court. The complaint of breach of fair hearing can only be raised and avail a litigant when in fact the right had been denied. The admonition of the apex court in this regard is instructive. See the cases of NNPC versus Clifo, Nigeria Limited, Imonike versus Unity Bank PLC, Eze versus Spring Bank PLC, Osakwe versus Nigeria Paper Mills Limited, citation supplied. In Adebayo versus HE Ogun State, 2008, 7 Nigeria Weekly Law Report, Part 1085, page 201 at 205 to 206, Toby JSCL as follows, I quote, Learned counsel for the appellants who roped in the fair hearing principle. I have seen in recent times the parties who have bad cases embrace and make use of the constitutional provision of fair hearing to bamboozle the adverse party and the court with a view to moving the court away from the life issues in the litigation. They make so much weather and sing the familiar song that the Constitution is violated or contravened. They do not stop there. They rake the defense in most inappropriate cases because they have nothing to canvass in their favor in the case. The fair hearing provision in the Constitution is the machinery or locomotive of justice, not a spare part to propel or invigorate the case of the user. It is not a casual principle of law available to a party to be picked up to wield in a case and force the court to apply it to his advantage. On the contrary, it is a formidable and fundamental constitutional provision available to a party who is readily denied fair hearing because it was not heard or that it was not properly heard in the case. Let litigants who have nothing useful to advocate in favor of their cases leave the fair hearing constitutional provision alone because it is not available to them just for the asking. End of quote. I had waded into the facts of the evidence in this case. The claimant was issued 2 queries, that is Exhibit C3 and C3A, and his reply to the queries are contained in Exhibit C3A and C6B. In his reply to the query in Exhibit C6B, the claimant admitted the allegation of illegal sale of file jackets and tendered his apologies for the mistakes. It is also on record that the claimant was invited to the JSDC and that he made his representation before the committee. In Exhibit D1A, the report of the findings of the Committee on Illegal Sale of Student File and Unruly Behavior is that The claimant admitted that he was engaged in illegal sales of the student files and that the act was corroborated by all the witnesses that appeared before the committee. While answering questions on the cross-examination by learned defendants counsel, the claimants testified as follows, I quote, "It is true that after my transfer to the preclinical department, there were allegations against me and appeared before the faculty disciplinary committee. One of the recommendations of the faculty disciplinary committee is for my redeployment. It is correct that I appeared before the GSDC on this allegation. It is true that GSDC discharged the allegation of theft of phone, laptop, and mini speakers against me," end of quote. The claimant also admitted under re-examination that he sold file jackets. By the copious admissions of the claimant, it is my firm view that the argument advanced by learned claimant counsel on the distinction between student file and student file jacket is mere semantics and of no moment. I do not agree with the submission of the learned counsel that the evidence of DW2 on the issue of file jacket or student file jacket is contradictory. The argument is hereby discountenanced. The law is settled that what is admitted needs no further proof. A party does not set out to prove that which is admitted. Say the cases of Olanle versus Ekwelendo, Akintola versus Sholana, Energy and others versus Agaji and other citations supplied. Having admitted to the allegation, the complaint of breach of fair hearing does not avail the claimants and are so hold. The claimant further contends that the first defendant or its agent acted ultra vires for trying and finding him guilty of the offense of theft that is only triable by a court of competent jurisdiction. It is on record that the claimant was issued the query for allegation of missing money in January 2015. It is equally on record that a letter, Exhibit C4, was written on the 8th of August 2015 to the claimant for the refund of the missing money. The testimony of the claimant in paragraphs 15 and 16 of his statement on oath is that a monthly deduction of 11,437 naira 50 kobo was made from his salary for 3 years from September 2015 to September 2018. To put it differently, the claimant agreed to the decision for the deduction and never complained that the deduction was made for a period of 3 years from a salary. The claim for refund is being made 3 years after the money was deducted. It is settled law that if a person with full knowledge of his rights, interests, profits, or benefits conferred upon or accruing to him by and under the law intentionally decides to give up all this or some of them, he cannot be heard to complain afterwards that he has suffered by his not having exercised his rights. See the cases of Ariori versus Elemo, Majeobaje versus Bello and other citations supplied. In the circumstances, it is my view that the claimant has waived his right to complain or object to the constitution of the members of the committee and to the decision of the committee for deductions that had been made from his salary since 2015, and therefore, consequently, has stopped from raising the issue. And as a whole, I should also remark that as contained in Exhibit C7, the reason for the termination of his appointment is not for the missing money, but illegal sale of student files and unruly behavior. In totality, the claimant has failed to establish that the termination of his appointment by the first defendant is unlawful. And as a whole, on the basis of the foregoing analysis, therefore, I must and I hereby resolve the sole issue for determination in the suit against the claimant. It is therefore the conclusion of this court that the claimant's claim lacked in merit and in substance. The suit shall be, and it is hereby, accordingly dismissed. The defendants pray for a payment of cost of 500,000 naira in the counterclaim. Generally, the law is that cost follows events, and it is awarded at the discretion of the court, whether or not specifically claimed by a successful party. And like all other judicial discretion, it has to be exercised judicially and judiciously. Without further ado, the defendants are not entitled to the counterclaim for costs. The counterclaim is hereby accordingly dismissed. Parties shall bear their respective costs.
As a court, thank you, my lord, for the judgment. We are most obliged.
Thank you. Somehow the judgment will get to Kaduna before the end of next week or the following week. Or you can always you can access it, because I will post it to the judgment portal of the NIC by the end of today. So you can access it for whatever reason. But the hard copy will be transmitted sometime later.
Thank you. We are most obliged. Have a pleasant day.
I wish you the same. Yes, you can call the second case.
Case number 3. NICS/KD/03/2022 between Adeniyi Mohammed and MTN Nigeria. The law court is absent.
Please, Your Lordship.
Yes, please.
Please, Your Lordship. Please, Your Lordship. Mohammed Etubi is my name.
Parties absent, who is appearing?
May I please this
Please, Your
honorable court?
Lordship.
Sorry, I didn't hear the claimants cancel. Can the claimants cancel? Please announce their appearance. I didn't hear that.
Please, Your Lordship.
Yes, please.
Please, Your Lordship. Mohammed Etubi is my name.
Mohammed?
Etubi, my lord. E-T-U-B-I.
E-T-U-B-I. Yes, the appearance is for the claimant.
Yes, my lord.
Yes.
May I please this
Defendant?
honorable court? May I please this
Yes.
honorable court, Ogechi Ogbonna, Senior Advocate of Nigeria.
Yes.
Your Lordship, I humbly appear for the defendant.
Did you say SN?
Yes, Your Lordship.
Congratulations.
Thank you, ma. Most grateful, Your Lordship.
Okay. Judgment. The claimant instituted the instant action via complaint and statement of facts filed in this court on the 8th of February 2022, and by the operative amended claim, complaint, and statement of facts filed by the leave of court on the 29th of June 2022. He claimed against the defendant. The reliefs are set out as follows. We have 2 reliefs in 2 and 3 alternative reliefs. They are stated on the face of the judgment. I shall skip this to save the time of the court. Expectedly, the defendant contested the claimant's claims by filing a statement of defense deemed properly filed on the 14th of October 2022. The claimant's reply and additional witness statement on oath was deemed filed on the 26th of January 2023. At the plenary trial, the claimant testified in person by adopting a statement on oath as his evidence in chief and tendered 4 documents in evidence as exhibits. He was thereafter cross-examined by the defendant's learned counsel. The defendant, in turn, fielded one Olarinwaju Babarinde, the customer's relationship officer, as the sole witness. The witness adopted a statement on oath as his evidence in chief and tendered no exhibits. The witness was in turn cross-examined by the claimant's learned counsel. At the close of the trial, parties were ordered by the court to file and exchange their written final addresses as prescribed by the provisions of Order 45 of the rules of this court. In the final address deemed filed on the 7th of November 2023, learned counsel for the defendants, Ogechi Ogbona Esquire, now SAN, raised 5 issues as having a reason for determination in the suit, namely, 1, that the suit started bad, 2, whether there is privity of contracts between the claimant and the defendant, including upon a consideration of the pleadings and the evidence led by the claimant in his reply to the statement of defense. That is, paragraph 5, the claimant also says he was only a third-party beneficiary of the contractual agreement between the defendant, Menkos, CNSSL, Inson BPO International. There was no privity of contract between the claimant and those contractors in their arrangements with the defendant, end of quote. 3, whether the claimant has led sufficient evidence or disclosed facts to justify being granted the declaratory and other relief sought in the suit against the defendant. Propriety of the claim of 19 naira 150 per month, 2,500 excuse me, is it 2,500,000 as general damages and costs. The claimant in turn filed his final address, also deemed properly filed on the 24th of January 2023, wherein A. Abdusalam Esquire of Learned Counsel distilled 4 issues as having a reason for determination in the suit, namely, whether the claimant, through a preponderance of evidence, has established the liability of the defendants to entitle him to judgment. 2, whether the statement of defense and the viva force evidence of DW1, there is a valid statement on oath on behalf of the defendants in the suit. 3, whether the defendants, having not ab initio embodied the terms of employment and termination of the claimants in a written document as required by law, can successfully raise time bar as a defense to the suit. 4, whether defendants can, on the totality of the evidence before the Honorable Court, successfully raise the defense of limitation of action in the suit. Upon a proper appreciation of the totality of the pleadings of the respective parties, the evidence adduced at the trial, and the totality of the circumstances of this case, it is my considered view that the suit must be decided on a lone issue without prejudice to the issues severally formulated by learned counsel to the respective parties as follows. I quote, whether or not the claimant established his entitlement to relief's claim against the defendant, end of quote. In proceeding to determine this issue, I must state that I had carefully considered and taken due benefits of the totality of arguments canvassed by the respective learned counsel in their written final submissions, to which I shall endeavor to make specific reference as I consider needful in the course of this judgment. I shall further state that this judgment was initially slated for the 3rd of June 2024, but the Nigerian Labor Congress embarked on a national strike on that day, and the judgment was further adjourned till today. Now it is considered pertinent to begin a consideration of the issues at stake by adverting to the fact that the claimant has sought declaratory reliefs in the suit. The implication being that the burden for him to prove the allegation leveled against the defendant exceeds the regular burden provided in sections 131 and 132 of the Evidence Act 2011. The settled position of the law from time immemorial is that even though the power to make a binding declaration of rights is discretionary in nature, a court will only grant declaratory relief sought in an action principally on the basis of the evidence adduced by the claimant without recourse to the evidence called by the defendant. The burden of proof on the claimant is in establishing a declaratory relief to the satisfaction of the court is somewhat heavy in the sense that such relief is not granted even on the admission of the defendant, as the claimants must lead credible evidence in proof of the declaration of rights it seeks from the court. An exception to the rule of pleadings that what was been admitted requires no further proof is that the declaratory relief cannot be granted without evidence, and it is not granted based merely on default or defense or on admission by the adverse party. See the authorities of Domains Nigeria Limited versus Nwakowa, Ogolo versus Ogolo, Ndayako versus Dantoro, and Olabanji versus Omakwena citation also applied. Proceeding on the footing of this legal principle, therefore, the task the court is to undertake now is to examine the evidence on record as adduced by the claimant and the law applicable thereto in order to determine whether or not such evidence has satisfied the requirements of proof imposed by the provisions of section 131 and 132 of the Evidence Act as amended to substantiate the claimant's claim as endorsed. Excuse me. The case of the claimant as told by him is that sometime in 2011, he was engaged as a customer care representative, CCR, of the defendant at the Kaduna office. That thereafter, he attended a 2-week induction program at the Abuja office of the defendant, and upon completion of the induction program, he was deployed to the Kaduna office as one of the customer care representative. The claimant contends that he was only issued with an identity card, but was not issued a letter of employment or any document. The claimant testified further that he was placed on a monthly salary of 37,050 naira, effective from September 2011, and the salary continued until the 8th of December 2015. According to the claimant, prior to 8th of December 2015, the defendant had prepared himself and other CCRs for transfer to Ilori or Ibadan offices of the defendant, and that they had been instructed to wait for the transfers, but rather than transfer him, the salary kept fluctuating between 90,150 naira to 101,000 naira, 101,730 naira 57 kobo. The last salary paid was in September 2015. The claimant contends further that the defendant has been in perennial violation of extant provisions of Labor Act by failing, refusing, and/or neglecting to issue his letter stating the terms of his employment. To buttress his case, the claimant tendered in evidence a statement of accounts with EcoBank, Guarantee Trust Bank, and a letter titled Change of Outsourcing Arrangements for MTN Call Centers, respectively, as Exhibit C2, C2A, and C3. Evidence on record as adduced Evidence of record as adduced by DW1 is that the defendant has no contractual relationship with the claimant, that he was not engaged by the defendant as a customer care representative or in any capacity, and that the defendant did not arrange for him to attend an induction program for 2 weeks as alleged. DW1 testified further that letters of employment are only issued by the defendant to employees that are employed, that the identity card presented by the claimant is not a staff identification card, but the same was issued to identify staff of contractors, that is, outsourced services to the defendant, to enable such staff have access into designated areas within the facilities of the defendant. DW1 also testified that the customer care services of the defendant at the material time was outsourced to CNSSL Contract Center Limited, that CNSSL recruited staff to execute its contract with the defendant, and the money that was allegedly paid to the claimant's bank accounts did not emanate from the defendant. DW1 maintained that the claimant is not entitled to his claims and contends that the claimant's suit is statute bad and abuse of court process. Now, the task the court is to undertake is to examine the evidence of record as adduced by the claimant in order to determine whether or not the evidence has satisfied the requirements of proof imposed by the provisions of Section 131 and 132 of the Evidence Act as amended to substantiate the claimant's claim as endorsed in paragraph 28 of the Statement of Facts. Essentially, his case is that his employment with the defendant still subsists. The claimant alleged that he was engaged as CCR of the defendant sometime in 2011 and that he attended a 2-week induction program at the Abuja office of the defendant. His grounds is that he was not issued with a letter of employment. The claimant further contends that since he was employed, his salary fluctuated between 90,150 naira as of December 2015 to 16,031 naira. It contends that he has been waiting for the defendant to transfer him to either Ilori or Ibadan, or office of the defendant, but to no avail. At this juncture, it is imperative to determine the issue raised by the learned claimant's counsel in his final written address of the validity of the witness statement on oath of the defendant's counsel of the defendants for non-compliance of Section 1112 of the Evidence Act and Sections 5 and 10 of the Oaths Act. Learned counsel argued that having admitted under cross-examination that his statement on oath was signed in his office, the sole witness of the defendant has no valid statement on oath and urged the court to hold that the evidence of DW1 is invalid. The cases of Eruku versus Eruku and another, Chidubem versus Ekena, citation supplied, and Adegbola versus Oshiyi were cited to buttress his submission. It is on record that while testifying on the cross-examination, DW1, the sole witness of the defendant, testified that his disposition was signed in his office. The law is that such deposition on oath must be signed in the presence of the person authorized to administer oaths. As correctly submitted by learned claimant's counsel, statement on oath, such as that of the DW1 that was signed in his office, offends sections 112 and 117 of the Evidence Act, section 19 of the Notaries Public Act, and the Oath Law. See the cases of Aliyu versus Bulaki, Buba versus another. Buba and another versus Mahmoud and another, citation supplied. Without further ado, the witness statement signed by DW1 and his office is incompetent and inadmissible, and it is hereby expunged. Having failed the statutory test of authenticity and admissibility, having struck the witness statement of defendant's witness, the cross-examination is expunged from the records of the court. Now, the law is still tried that the party who asserts has the onus or duty to prove his assertion or claim by adducing credible evidence. By Section 136 of the Evidence Act, the burden of proof in civil matters lies on the party who will fail if no evidence at all was adduced on either side. Thus, the burden of the onus or burden lies on the claimant to adduce credible evidence in proof of his claim or defense, but strictly on the strength of his own case. In other words, where a party fails to discharge this burden, then the opponent need not prove any facts, and the party alleging cannot rely on the weakness of the opponent's case. The imperative position of the law remains that you asserts must prove. See the cases of Lamy versus DPMS and the case of Onoshigo versus Glow and another, citation supplied. The argument of the learned claimant's counsel is that the claimant had proved by Exhibit C1 that he was engaged by the defendant, even if the payment of a salary was made by those to whom the payment was outsourced. Learned counsel submitted that the contractors are agents of the defendant and they are liable for the acts done by their agents. Learned counsel cited the case of SGBN versus Eleganza Industry Limited, 2004, 8 Nigeria Weekly Law Report, Part 875 at 432, in support of a proposition. Learned counsel further argued that the defendant violated the extant provision of Section 7(1) Labor Law by refusing and neglecting to issue the claimants a letter containing the terms of his employment. On its part, the defendant categorically denied the claimant that the claimant is entitled to his claims or that the claimant was engaged in its employment as CCR or in any other capacity. The defendant contends that at the material time, the customer care services of the defendant was outsourced to CNSSL Contact Center Limited, and that this outsourced company recruited staff to execute its contract with the defendant. I have taken a cursory examination of Exhibit C1, the identity card tendered by the claimant in proof of his claim that he was engaged by the defendant. It contains the picture, name, designation, and signature of the claimant. It also has the logo of the defendant. On the reverse side are details of contacts for medical and purposes of emergency. The expiration date of the identity card is stated as the 28th of February, 2017. The implication of this is that the said identity card is invalid since 28th of February, 2017, the date of its expiration, and I so hold. I shall further remark that there is no evidence to prove the claimant's allegation that he attended 2 weeks induction program at the defendant's Abuja office. In further proof of his claims, the claimant tendered Exhibit C3, an email dated 21st of May 2015 from one Ikechukwu Ogbalachu of MTN Apapa Service Center to independent service contractors. While answering questions on the cross-examination by the learned defendant counsel, the claimants testified that Exhibit C3 was from one Ikechukwu Obalachi, a staff of the defendant, that the said exhibit was sent to Intranet, an independent service contractor, and that this was sent to all members of Intranet, including himself. The claimants testified further that the payment of the 21st of May 2012 in Exhibit C2A was based on an outsourced arrangement between the defendant and the outsourced company. The claimant also testified that he never made any complaints about the payments of his salaries. I have taken liberty to reproduce the relevant portion of Exhibit C3. The subject matter of the email is, I quote, change of outsourcing arrangements for MTN call center, end of quote. Paragraphs 2 and 3 thereof states as follows, I quote, please note that we are in discussion with the management of MTN for details of the new arrangements, and management will provide you with regular updates on the situation. In the meantime, I urge you all to kindly continue with your schedule as we are still in contact and do have obligations of performance to MTN. Now, outsourcing is the process of contracting a business function or any specific business activities to specialized agencies. The primary reasons for outsourcing are to reduce costs, improve efficiency, access specialized skills, and focus on core business activities while leaving non-core functions to external experts or entities. Labor outsourcing is a species of outsourcing. In such arrangements, while there is a contract of employment between the labor contractor company and the employees deployed to the user companies, no such contractual relationship exists between those employees and the client user companies, even though they work directly for them. In Petroleum and Natural Gas, Senior Staff Association of Nigeria Pingethan versus Mobile Producing Nigeria Unlimited, 2013-32 Nigeria Labor Law Report, part 92 at page 243, a declaration was made by this court that outsourcing is a lawful enterprise in Nigeria, and it further noted that the International Labour Organization does not brand outsourcing or triangular employment as invalid or unlawful, and neither has the practice been labeled as unfair labor practice by the ILO, by enjoins that respective laws of member states on the practice of outsourcing must be applied and respected. The argument of learned defendants counsel is that the claimant admitted in paragraph 5 of his reply to the statement of defense that he was only a third-party beneficiary of the contractual arrangement between the defendant and Menkos, CNSSL, and Insom BPO International, and that there is no privity of contracts between the claimant and the defendant with regards to the contracts with the said companies. Learned counsel submitted that declaratory reliefs are granted upon proof by cogent, credible, relevant, and admissible evidence, and further submitted that the claimant has not discharged the burden to entitle him to any of the reliefs being sought. Now, having admitted that there is no privity of contracts between himself and the defendant, and having admitted that the payments of the salaries of 31st October 2011, 1st of December 2011 in Exhibit C2, and the payments of 21st of May 2012 in Exhibit C2A were made by outsourced arrangements, the pertinent question is, as the claimant's previous claims against the defendant, my answer to this poser is an emphatic no. As I earlier held, Exhibit C1, the identification that the claimant's basis claim expired and has become invalid since 2017. In closing the curtains of this judgment, It is considered pertinent to restate the time-honored cardinal principle of the judicial process that the relief sought by a claimant in an action is fundamental to the fate of that action. Indeed, the relief sought is the bedrock and life wire of an action. Therefore, where the relief sought is uncertain, uncategorical, or is not supported by evidence on record, or does not reflect the course of action, the entire exercise and proceedings become futile, and there will be nothing for the courts to grant at the end of the day, and the courts will be compelled to throw out the action. See the case of Gold Day Company Limited versus CDMB PLC and Uzowoku versus Ezeonu 2, citation supplied. Keeping this principle in focus, the claimant's claims fail in its entirety for failure to prove his claims. On the basis of the foregoing analysis, therefore, I must and I hereby resolve the sole issue for determination in this suit against the claimant. It is therefore the conclusion of the court that the claimant's claim lacked merit and substance. The suit shall be, and it is hereby accordingly dismissed. Parties shall bear their respective costs.
As the court pleases.
As the court pleases. We are very grateful, my Lord, for the well-enlightened judgment. We are grateful, sir, for all the time expended in writing this lucid judgment.
We thank the Honorable Court for the judgment and for the volume of work put in. Most grateful.
Like I stated in the previous case, the judgments will be posted on the NIC portal by the end of today, but the hard copy of the judgment will be sent subsequently, probably next week. But because I envisage there will be public holiday next week, it might not be feasible for you to get it next week, but you'll get it sometime. The registry will let you know when they have the hard copy of the judgment. Thank you.
Your Lordship, please, Your Lordship, can I humbly pray, Your Lordship, whether it will be possible to get the CTC in Abuja?
Yes, you can, if you have somebody that can come and pick it up here.
Yes, ma'am. I'm based in Abuja, Your Lordship, so I can apply.
Oh, really? I didn't know you were based in Abuja. So you can always apply and I will avail you with a citizen.
Most grateful, Your Lordship.
Thank you. The court will rise.
Court.
Thank you.
So Registry NIC, thank you and thank you and thank you.
Thank you, sir. You're welcome.